performance. We're grateful to you for making time to be here. By way of introduction, my name is Charles Jallo. I happen to be a founder of CILPA, the Center for International Law and Policy in Africa, and a professor of international law at Florida International University. And in a different capacity, have the privilege of serving as a member of the International Law Commission. Before proceeding to the substance of today's event, and on behalf of CILPA and myself, I'd like to start with some words of appreciation, and I'll try to be very brief, given that we are behind on time. So first, of course, to the permanent mission of Sierra Leone, which is collaborating with CILPA in co-sponsoring this event. We're very grateful, in particular to Ambassador Michael Imran Kanu, and of course, the full staff at the mission, including Hawanatu Kebe, who is not out of the room, but the one who went and fetched me, and has been doing everything to help organize the event. And on my side, of course, in terms of the center, my colleague, Ms. Claire Stridlum, who is actually still right now working hard trying to figure out what we can do about the display. Second, of course, to the speakers who I'll be introducing momentarily, Lorraine Smith Van Lim, who's to my immediate right here and happen to be in the room in person. And of course, the two additional colleagues who are online, Mr. Setondi Roland Ajovi, and of course, Mr. Jeffrey Lugano, three experts who deliver some excellent papers that we're hoping to launch, that we are launching today as part of CILPA's International Criminal Court in Africa project. The soft copies of their papers are available online on the CILPA website. And of course, we have some hard copies here in the room. So please feel free to take a copy so you can have a look at them when you have a moment. Of course, Ambassador Kanu, who needs no introduction, also wears a different hat because he happens to be one of the two state representatives that are responsible for the permanent review mechanism. He's been a key supporter of CILPA over the years, and in fact was at the meeting in Freetown when we did the workshop for these particular papers last year. So I'm grateful to him for his multiple collaborations. And lastly, our supporters, the Open Society Foundation. Before I hand it over to the consultants, who the plan was to give you about 10 minutes overview of their very rich papers, which certainly wouldn't do justice to the papers. I understand Ambassador Kanu has to run because he has other meetings. So I'm going to give the floor over to him. Just briefly, in terms of CILPA, our goal is to work on issues that concern African states, in particular in the area of international law, issues that bridge research, policy, and practice. And we have an admittedly big and ambitious goal of being one of the leading think tanks on international law in Africa, based out of Freetown, Sierra Leone. This particular project was conceived a little while ago, basically to pick up on the developments at the International Criminal Court concerning some of the criticisms of the International Criminal Court, which had happened over the years. A wide range of issues that I'm sure many colleagues are aware of had been flagged over many years, including by African states, which had what some described as backlash towards the ICC. And it's very interesting that it was in May 2019 that the Assembly of States Parties finally recognized that there are some concerns about the ICC, provoked by the letter from the principals of the court, who requested actually the establishment of an independent review mechanism and a process that was considered to be supposed to be inclusive, state party driven, for identifying and implementing measures to strengthen the court and improve its performance. We all probably know the history very rapidly. I'll just highlight a number of issue areas that were identified as thematic clusters, one on governance, the judiciary, that's the second, and thirdly, investigations and prosecutions, all of which were supposed to be, if you will, receiving the spotlight of the independent expert review process. There are a number of other priority areas that were identified that would be for the states parties themselves. One dealing with the question of strengthening cooperation with the court, addressing issues of non-cooperation, complementarity, and equitable geographic representation and gender balance within the court. We all know that the IER presented this independent expert review, presented a report, a very fat report in September 2020, with a series of no less than 384 recommendations, some of which were intended for short-term, medium-term, and long-term implementation by the court itself. We know that subsequently in December of 2020, the Assembly of States Parties itself decided to establish this review mechanism. I'm going to be certain that you'll be hearing a little bit about that from Ambassador Kano. And we know that the states have been engaging also with civil society in terms of implementing those recommendations, of course, alongside the court itself. So that's all I want to say, but I'll just make a particular point concerning this review process. There was concern right after the report was issued about, and questions raised about the extent to which the review mechanism accommodated the long-standing concerns of African states. So that's for us from the point of view of CILPA, what led to an examination of the topic, the idea being to bring independent experts with subject matter expertise to look at issue areas of particular relevance and concern to African states, with the view to determining the extent to which the formal processes that were established by the Assembly were taking on board those African concerns. And the African concerns, I don't think anyone here needs to be convinced, are particularly important. Not only is the largest regional group within the Rome Statute system, it so happened to, until very recently, be the entire source of the docket of the court, both the situational docket and, of course, individual cases. So from the point of view of CILPA, it was very important to have independent expert review of this process from outside, and we are very pleased that these consultants looked at this issue, and we have the papers I see they've been circulated in the room, the outcomes of their research, which will be presented momentarily. I'm going to stop there. There could be a little bit more to say about this, but let me go right to Ambassador Kano, who, as I said earlier, is a permanent representative of Sierra Leone and is wearing a slightly different hat. Obviously, he is here in his own capacity, but also I'm glad to say a friend and supporter of CILPA, and in fact, one of the key players in terms of the African submission to the IER process. So Ambassador Kano, if you would, about 10 minutes or so, what you want to share with us before you have to run. Thank you very much.
I'll do better. I'll do 5 minutes.
Oh, wow.
Take time for our consultants to this issue. Professor Jallo, our consultant, who worked very hard on this issue, Mr. Adobe, Dr. Lugano, and certainly Madam Van Leen, thank you so much for the time you spent on this issue. I do recall engaging with you in Freetown when we had the workshop. Colleagues, thank you for making time to join us. It is a busy period, and so I'm grateful to Professor Jallo for allowing me to speak briefly on this issue, as I have to proceed to other engagements, particularly relating to the review mechanism, and for which we need to turn in some documentation as fast as possible. The title is Bringing the African Perspective to the ICC Reform Process. And what we have done in the review mechanism is to distinguish the work of the review process to the thinking of, is it a reform of the ICC? I'm not going to split hairs about review and reform, but essentially what we are talking about is strengthening of the International Criminal Court and the Rome Statute system, back to the resolution and all of the reports which were presented, titled Strengthening of the International Criminal Court and the Rome Statute system. So in a way you can say what has been the contribution or the African perspective to the recent endeavor to strengthen the court and the Rome Statute system. I will start by just highlighting some critical steps that were taken to ensure that the African perspective, the African interests were fully reflected in the process, and certainly one that led to even the formulation of the review mechanism in a way that takes account of the African interests and priorities. I will start with what was the status quo when the review was being discussed and the need for the review, which was we had a lot of arguments and a lot of presentation by mostly African representatives as to what they see that was going wrong in the context of the court and the Rome Statute system. And of course, there's enough literature on the African bias. You only need to Google Charles and ICC and you see everything that you need to see on that. So I need to go into that. But of course, the argument has always been made about the stages of the relationship between the court and Africa, and it's not as simple as we tend to present it. But we see the movement from being very supportive to the point where there was a decision or discourse on mass withdrawal from the court. And so it came to the point where there was a recognition by the state parties that there is need for some form of a review of the court to strengthen it. The letter that led to this, of course, from the principals of the court, and then discussions by the state parties, started without an active African engagement. In the informal consultations, in the meetings that were proceeding then, there was involvement of a couple of delegations from the African state parties, but there was no concerted view from the region. However, at that point in time, there were already existing proposals made by African states, particularly during ASP sessions and during the general debates. Some were submitted within the framework of the Rome Statute and the ASP facilitations, but they were not taken forward. So we do, at that point, there were a number of African proposals on the table, but they were not taken forward. And so the idea was to ensure that those views and proposals will be taken forward in the review process. And so when we met in The Hague in the ASP 19, I believe, based on the African Union summit decision to engage in this process constructively in order to influence the review, there was an agreement to set up a form of a facilitation or coordination on this. And I had the honor then to be asked by the African group to coordinate the group on this issue. And I guess that was the beginning of my involvement in the review process. But what we did at that time was to agree to firstly only proceed with agreeing to the resolution, which was adopted by consensus, on the basis of examining the list of experts. So the view which we brought forward was to ensure that there was African involvement. So African perspective meant African involvement and African experts being appointed in the panel of experts to the IAER. And we see that right through in terms of the chair of the independent expert, one of the respected judges and scholars, but of course, we had African representation in the three clusters. The next real stage was engagement with the process. We agreed on engaging with the independent experts. Eventually, we were able to submit in writing views on the review process. It came in a bit late because of the intervention of the COVID at the time. We're grateful to have received support from CILPA. We were able to bring together all of the proposals that were been submitted at the time by the African state parties, which we resubmitted. A critical point in the process then was a response from the independent experts who said that they have been tasked to deal with specific issues within the terms of reference, so they could not deal with more substantive issues leading to the amendment to the Rome Statute. And most of the submissions and proposals were made by African states was basically to amend the Rome Statute, whether to include corruption as one of the crimes within the jurisdiction of the court, to more complex issues like deferment of indictment, as given the experience with the Security Council relating to the Kenyan situation. We still continue to engage with the independent experts when they submitted the report, and I believe it's the reaction of the African group in terms of welcoming the report and being in a position to work on the basis of implementing the 184 recommendation that led to negotiations of the resolution. In the negotiation of the resolution, there were two critical views. One mostly put forward by Western Europe and other states who believe that we needed a lean, efficient body to take forward the work of the independent experts. And the African group emphasized on the notion of ensuring that we have representation and ownership. And so we ended up with a compromise, a review mechanism that had two state parties representative and had country focal point, essentially covering the 5 regional groups within the ASP. The two state party representatives ended up being myself and Ambassador Van der Eysel, and we were given specific mandates within the resolution. First is to categorize the recommendations, 384, within a limited time, which we were able to do. Second was to ensure that we assess those recommendations, and we were asked to develop a plan of action, sort of a roadmap to do so. We were able to develop a comprehensive action plan, and when I gave the report on behalf of the review mechanism at the start of this session, I think the only outstanding recommendations that we are yet to be assessed about 2.5. The review mechanism was able to assess all of its recommendations. So in a way, we've been able to meet the mandate of the review process. But substantively, the engagement of the African group has led to the shaping of some of the most important aspects of the recommendations. So whether it's on working culture, geographical representation, and gender balance. And up to now, we're discussing the important issue of tenure. Recommendation 105 on tenure is an important recommendation that really will lead to some form of revitalization of the court itself. But the African group has made its view very clear that tenure cannot be discussed without also looking at the critical issue of geographical representation and gender balance. The hope is that during the course of this ASP, we'll be able to find some form of a compromise between the various points of view on this issue. Finally, we are discussing the future of the review mechanism. I think there's still scope for the African group and the African perspective to be fully incorporated in our discussion. We'll have a plenary on this. The hope is that, as they've always done in the plenaries of the review mechanism, the African group would take the floor and offer its views on the future of the review process. To summarize, it's really pleasing to note that from the commencement of the discussion on the review of the International Criminal Court and Law Statute System to where we're at now, the African perspective has been carried through, particularly through the active engagement of the African state parties. In an engagement in Freetown, there was a question as to what about African civil society. I think there has been accommodation for that as well, since the work of the review mechanism has been so far transparent and inclusive. But don't take my word for it, listen to the consultant. And I said 5 minutes, hopefully not so much over 5 minutes. Really, I'll miss the discussion, but thank you for joining us. The delegation of Sierra Leone is always happy to collaborate with CILPA to ensure that we continue to have discussions in the international multilateral system, but with a specific focus on Africa, because I think we have a lot to bring to the table, and it also ties in with our interest in promoting pluralism in the international system. I'll stop for now. Thank you, Jim.
Thank you so much. Let me give a round of applause to you, sir. Thank you for making time to be here. You can see why we're very excited to have Ambassador Kano giving his own involvement in the process and, of course, strong support for CILPA. Let me move rapidly for reasons of time to the panelists. I'm going to start with Roland Ajobi, who will speak very briefly to the background on the relationship between African states and the ICC. And then after, we'll hear from Jeffrey Lugano, and then, of course, last but not least, we'll hear from Lorraine Smith-Van Leeuwen to my immediate right. So, Roland, I think we're a little bit short on time, so if we can do even on that, you have 10 minutes, that was promised, but if you can do even less, it would be much appreciated. I know it's a big task because you've done a wonderful paper and rich paper, but we do have the paper and hopefully folks will have time to read it. So Roland, take it away.
Thank you very much, Charles. Ladies and gentlemen, good afternoon or good evening to everyone. I'm not an ambassador, but I'll try to make it shorter than the time provided to follow the ambassador's example. So in the paper, what I tried to do is, the aim was to look into how Africans' concern could be considered and taken on board through the review process. But to start with, I tried to clarify the relation between Africa and the ICC in 2 steps. First, what is the current state of affairs, looking at the role, the docket of the court, what is the place for Africa and how it has evolved over the year. No need to go back to that and discuss it. And then I try to dispute the perception of the relation, because when you look into the media, it seems that Africa is at conflict with the ICC. And I tried to explain that, in my view, Africa is not an homogeneous entity. You have the continent, which doesn't speak anything because it's a land, but within the continent, you have the leadership, you have the countries, you have the individual, you have different groups, you have the civil society, and one need to look at every of these different stakeholders, and you'll realize that the perception of the relationship with the ICC vary a lot. And it's not as bad as one will see if you look only at the media and the coverage. And that also, it's in the paper. I don't need to go through it, but I will just mention there is a high level of conflict between the African leadership of some country, maybe most of the country, but some country, which does not match the position of African civil society, which are representative of the African people. So that conflictual relation is not completely evidenced in my research. Then what was most interesting for me was, what are the African concerns vis-a-vis the ICC? What are the issues African states want to take on board with the ICC, which they want to see change in? And my finding has been that there are two types of issues in this process. Some of the issues are of legal nature. Some of the issues are functional, operational, to make the court deliver better. And I hold the view that the legal nature issue could not be addressed through this review process, which is not a state-led review or state-led discussion as we are used to in international law, because the international norms are developed by the states. Even if individual experts, civil society are able to participate and influence state view, it's developed by the state. So we need to review what Africa is expecting, African states are expecting, and develop a better strategy. And three key issues are identified in the paper, which are immunity for the head of states, universal jurisdiction, and the principle of complementarity, especially if you bring into the process of complementarity regional courts, because in Africa we have regional courts in different regions, and we have the African courts, which all have been developing a mandate in criminal justice, not to compete with the ICC, but to fill a gap and be able to play a role. So African states, African society are interested in an approach of the complementarity, which could include those non-national courts, which are the only one thought of in the complementarity. And that has been the core of my research, that in the immunity, on the immunity side, on the universal jurisdiction, those are issues of legal nature for which we might need different process, and international law has developed very good process to negotiate, to research legal issue and propose to the state and get consensus of the state around those norms, so that we have new norms, or we have a set of information which in the long run could be considered as constituting international norm. We need, as African state or as African concern, follow those well-planned process to get a result which will be sustainable, while the review process might not give that opportunity. On the complementarity, they are both practical, functional issue, and there are a substantive issue of legal nature. On that also, to either state on board the legal issue and follow the same process of international law, the progressive development, either through the Sixth Committee and the UN General Assembly, through the Assembly of State Party discussion, or through the International Law Commission to feed the work of the international organization. And on the practical issue, look into how to influence the operation of the court For instance, on the complementarity, there is a lot which is done between the courts and the specific institution to train them, to make them understand data, to help them develop their own practice, investigation, conduct of the trial, and so on. That can be done without any change in the legal nature, but it might have financial implication, it might have staffing implication, and the organs of the court need to take on board. So that level of change can be done through the review, certainly, but the substantive issue need to be taken on board through a different process, which I described for the two first. So in conclusion, I have made an observation of states, the key player, and who are the voice owner of the African society, are bringing valid issue. Not everything is not valid, constructive, but I'm afraid that the way in which they are getting the issue on the table through the process might not be the most efficient to get the result. And when they bring the issue, there might not be also a commitment in the long run to follow up on the issue, to make sure the issue is taken on board and properly discussed, talking bilaterally to other states to get a consensus around how they view the issue to make it progress. If you take the universal jurisdiction, it has been already 10 years. And where are we? Are we progressing? Are we anywhere we could say soon we are going to have an outcome to it? I'm not sure if now there is any clear understanding of where African states want to get this debate land. What are the form of norms they are looking for? And in my view, I'm not a diplomat, I'm not working for any state, but that's something the states need to review, the way they engage, the way they work on the proposal to make it operationalized through the discussion with other member states. I will stop there and I'll be happy to answer questions on the paper as we progress. Thank you very much for the opportunity, and I hope my presentation has been clear enough. Thank you.
Absolutely. Thank you very much, Roland, for being a team player, been very succinct. I know you wrote a very rich paper, and I look forward to engagement by colleagues. Please have a look at Roland's bio, which is in the paper. Very rich experience in international criminal justice, and APPA from his presentation. Let me move very quickly to Jeffrey Lugano, who is based at Kenyatta University in Nairobi, and he looked at the question of African state implementation of the Rome Statute and some of the issues that are tied to the reform process. So Jeffrey, if you can hear me, if you could put your camera, also maybe follow the example of the ambassador and Roland, 10 minutes or less. Thank you very much, sir.
Yeah, thank you so much, Charles. I'll try to be as brief as possible, and of course, within the timelines that you provided here. So, following on Roland's presentation, mine links to what he's just said and what my colleague Lorraine will say, but I was given a different task that relates to examining the domestic legal framework in the African states that today form part of the situation located at the ICC. I think we all know that the ICC is primarily an African court in that sense, that most court cases have been from Africa. So what I was tasked to do specifically was to assess the national implementation of the Rome Statute in select African situations. And with regards to looking at status of implementation of the Rome Statute, the missing gaps, but also the structural issues that underline the duty of these states in the war on impunity for atrocity crimes. So this kind of assessment was informed, as we all know, by recent calls for reforms at the ICC, but it more or less looks inwards at African states' readiness for performing the primary responsibility in the Rome Statute. And of course, the question is, can these African states perform complementarity, which is the cornerstone of the Rome Statute, so that it avoids a difference to the ICC, and this has the benefits of reducing the kind of pushbacks that we've seen between African states and the ICC, given that there is that question of an African focus, or rather an African bias at the ICC. So the underlying question that this paper that grapples with was whether African states contact the ICC has led to reforms in their legal orders in such a way that they would avoid deference to the court in future. And of course, the significance of the reforms is to satisfy the principle of complementarity, but also to foster cordial relations with the ICC. So in terms of methodology, what I did was a case study approach that considers a balance on a number of things, because it's not easy to research Africa without going to different countries and geographical locations. As my colleague has said, Africa is not a country, it's a geographical space that has different countries. So what I did was to select cases based on geographical locations, that is, selecting cases from the north, east, west, and central Africa. I also looked at the balance on the ICC's trigger of jurisdiction, where I looked at cases of UNSC referral, self-referral cases, but also pro motu, that is the court acting on its own motion. But I also looked at the legal traditions of these different countries and the balance on countries that have civil law traditions, common law, and Sharia law. And of course, these all speak to Africa's diversity and the context under which the Rome Statute diffuses on the continent. And of course, the caveat is that these cases that I selected really didn't speak about a representation of these different regions, because we know that African countries are unique in the political context under which the Rome Statute is demonstrated. But of course, they give us an indication of probably how the status of affairs is with regards to implementing the Rome Statute in these different African case studies. So with regards to situations, I selected Uganda, that is a state referral, but also sits in the east, common law tradition, Sudan, UNC referral, but also in the north, and Sharia law tradition, Kenya, pro motu, East Africa, common law tradition, Cote d'Ivoire, pro motu as well, West Africa, civil law tradition, and lastly, CAR, Central African Republic, that is a state referral, two situations there, that is regionally located in the central part, but also practicing civil law. So the main findings, which I think are important here, the rest of my methodology, you can flesh them out from a paper that is circulated to you, was that there are varying levels of domestic legal reforms towards compliance with the ICC system of justice in these different African countries. And of course, this much depends on the level of, or rather the method of reforming these legal traditions of these countries. But one critical finding that I found interesting was that these different countries have had several missteps that undermine their abilities to perform, or rather to effectively confront impunity for alleged perpetrators of atrocity crimes. And I looked at, for example, the fact that definitions are problematic in some cases. That is, definitions of Article 5 crimes, particularly in states that opted for the individual or and rather dynamic criminalization approaches. And this is examples of Sudan and CAR. And for definitions of core international crimes, I found that countries like Kenya, Uganda, and Cote d'Ivoire that have static or lateral transcription approaches have defined international crimes in domestic laws in ways that are compatible with the ICC. And that is to be contrasted with a selective implementation, for example, in Cote d'Ivoire that opted for the individual approach. And Cote d'Ivoire is particularly important here because it omits cooperation and irrelevance of official capacity, but also omits Article 8.2e that completes criminalization of war crimes. But if you look at the dynamic criminalization approaches that I noted in CAR and Sudan, we found that criminal acts, the definition of Article 5 crimes, are more aligned to customary international law rather than the Rome Statute provision. But also I found that there is a reformulation of crimes within these country statutes that depart from those in the statute. But more importantly, I found that definitions sometimes contradict those in the Rome Statute at times, and sometimes they're also inadequate definition of crimes. For example, Article 152 of CR's Penal Code deviates from the Rome Statute definition, and it extends protection to other groups. But also, Sudan also reformulates genocide definitions in ways that narrows the definition that is bound to create confusion in that definition of international crimes. Another main finding was that Sudan's definition of genocide departs from the Rome Statute and that of the Geneva Conventions that the ICC draws its definitions from. Then Sudan again is problematic in terms of failing on the definition of rape in line with the international standards. It also includes adultery as in the definition of sexual violence, and it creates ambiguities in the applicable rules and evidence. With regards to elimination of obstacles to prosecution, I also found some problematic cases, for example, in CIR, where there is no legislation on the responsibility of commanders and other superiors. Cote d'Ivoire, again, is also problematic in the sense that it omits superior orders and prescription of the law. Then Sudan, again, the Criminal Procedure Act of 2007 also prohibits the criminal prosecution of any Sudanese national in non-Sudanese courts, and it also makes no reference to the responsibility of commanders and other superiors and superior orders and prescription of law. I also found that on the relevance of official capacity, it is upheld in Kenya and Uganda, but still Uganda, the Constitution of Uganda of 1995 shields the president from proceedings in another court, with exemptions on crimes committed on existing in office as opposed to liability for international crimes. Then CAR, irrelevance of official capacity is only provided in a partial manner, whereas Sudan is more problematic that several statutes provide immunity for state actors. Then Cote d'Ivoire is yet to legislate on the relevance of official capacity. I also find that the statutes of limitation in Kenya and Uganda, it's recognized, but Sudan then here again exists as an outlier with the fact that it has non-applicability of statutes of limitation in the sense that international crimes have 10 years of prescription period. I also found the cooperation with the ICC as problematic in some cases, especially with regards to state parties to the ICC or to the Rome Statute, with regards to the fact that only Cote d'Ivoire is yet to enact legislation on cooperation, whereas CAR has cooperation legislation, but it's still problematic, especially given the fact that Article 14 of the Special Criminal Court law eliminates the ICC in dispute resolution. Then I found another problematic case in terms of witness protection, where most of these countries that I've studied as my case studies have not yet enacted statutes on witness protection, with most of them relying on informal protection mechanisms that are based on need basis, where here only CR and Kenya have legislation, but still with operational challenges. For example, if you look at the Kenyan case, we still have some cases that have been pending with regards to offenses against the administration of justice, with instances of witness intimidation and interference, with no movement on the state to investigate those cases. Then for CAR, there have been measures on witness protection, but then again the question comes in terms of putting measures into practice in such a volatile political environment. So with regards to victim-centeredness, again, only Kenya and the CA have legislation to this effect, whereas other countries have yet to put legislation. On penalties, the Rome Statute, of course, does not provide for it, suggesting that even the most serious crimes do not warrant it. But of course, we have some other countries within the case studies that I've selected, like Sudan, that have death penalty, that is both applicable for international crimes, but also for ordinary crimes, for offenses. Beyond these legal reforms, again, I also saw an instance where these countries are largely transitional societies, not just in Africa, but also we find the problem of these countries being transitional, being confronted with the peace versus justice conundrum, in which there is a long struggle, or rather a debate between the pursuit of criminal accountability and immediate concerns for establishing peace. And the whole idea of sequencing of the two tracks kind of becomes problematic. So though advocates for criminal accountability, like justice advocates in the ICC spectrum, are concerned with justice, there is also this sense that we need to, first of all, build peace. So there's this push and pull between achieving peace, but also having accountability. And this speaks to the sense that these transitional societies are kind of attracted to this notion of reconciliation and peace. And this kind of pushes justice to the back front. So this paradigm kind of leads to different arguments, but of course, these legal reforms that the ICC is championing are kind of confronted with these realities of alternative paradigms of transitional societies, that is the idea of sequencing between peace and justice. So, in a nutshell, we find that there is varying degrees of compliance in these African countries that I've selected, but of course, these compliance levels are contingent on the methods of implementation and the political context under which the legal reforms unfold. But then this calls for ways in which you can find a middle ground to kind of intervene in these countries and have them move towards compliance with the Rome Statute. So what I did was to call for rather activation of what we call a positive complementarity that has been used in the past to move these countries towards ratifying the Rome Statute. But of course, this will be more strategic and targeted to a number of things like training national officials in drafting amendments to the SEC implementing legislation and focusing on the missing and inadequate provisions, but also training national legislators on the missing links in their respective legal orders and the need for amendments. So I also call for special attention to these judicial afterthoughts like witness protection and victim-centeredness, which of course are novel concepts, but of course we will need to have something like model legislation that I call for that could be used to be a benchmark for these countries. That is all I have.
That's perfect timing. Sorry, I have to interrupt. We're going a little bit over time. Is that okay to conclude there? Fantastic. Yeah, okay, fantastic. Thank you very much. So I'm going to move rapidly. So thank you very much, Jeffrey, for that intervention. I hope you can still hear me. I'm going to move to the last but not the least, to my immediate right here, Lorraine Smith Van Leen, who picked up on the similar issues, but basically addressed some of the questions that Jeffrey alluded to, including the issue of complementarity and, of course, peace and justice and the question of cooperation. So Lorraine, who is, I think, known to most of the people in the room, is currently the founder and executive director of Talawa, Justice for Women, a nonprofit NGO, and before that wore a hat as a legal advisor for Redress and was based in The Hague, working also with International Bar Association. So Lorraine, about 10 minutes. And I'm going to sweeten the pot by saying we do have lunch. It's going to be coming shortly right outside. So in case that's an incentive for you as we go over to the conversation after Lorraine. So Lorraine, please, you have 10 minutes. Thank you very much.
Thank you very much, Professor Jallo. And colleagues, thank you for your patience. There's an imposter in the room. It's me. But the truth is, I'm not an imposter. The accent you hear is Jamaican. I consider myself part of the African diaspora. And as a result, I feel like there was some legitimacy in me seeking to tackle issues that are bigger than all of us. So I won't attempt to repeat what is in my paper. I'll just tell you some of the issues that stood out to me and to also flag a few issues that I think, interestingly, in the short time that we wrote the paper in the heart of COVID, how things have changed. Palestine had always been on the ICC's docket, but things have certainly escalated. Africa has been on the ICC docket for as long as I followed the ICC since I joined the International Bar Association. I was head of their monitoring project, the head of the IBA's office in The Hague. And the only cases we knew of was the case against Thomas Lubanga, then came some of the others, Central African Republic, Kenya, and some of the others. And I was part of all of the meetings where the discourse was around Africa being the target of the ICC. So then we saw the landscape begin to shift when Georgia came in the room, and then we are seeing Ukraine and we are seeing Afghanistan. So we recognize that in some ways I've actually been in circles where I ask the question, has Africa been forgotten? But obviously it cannot be, because even though we have investigations open and situations under consideration, the actual defendants that are on the ICC's docket are still from Africa. And so it was incumbent on us, and I was very grateful to Professor Jallo for the opportunity to look at the space within which African states, African civil society, and others, including African academics, would have the opportunity to contribute to what was one of the most significant processes that we've seen so far, I think beyond maybe the review conference in 2010. We've heard very eloquently from the ambassador, and he's been working quite in detail on the review conference. what the African role was. Because as a researcher, when I looked at the papers it didn't seem obvious to me that there was African engagement in the process. And then I understood a little bit more by listening to him that the African group spoke with one voice. So this is why, as I started to go through some of the historical record of the IER report, I could not identify the position of individual states, at least in the formal documents that were submitted. But then beyond looking at the formal documents that were submitted, there was also the debate in the context of the assembly itself, where African states would present their individual position, and across the board, the position was supportive. So my paper looks at the issue of whether some of the issues that African states were articulating either began at the time of the review or they preceded the review, and whether those that preceded the review were heard by the IER or ignored. My conclusion was that, and before I say that, let me preface what I want to say by reference to an academic and expert, Omar Ba. I think some of you may know him very well, who said that although the review looked at what he called the technical and the mechanical functioning of the ICC, what was missing, in his view, was the broader examination and assessment of the ICC's role in the broader geopolitical landscape. And his view was that that is a priority for Africa. In other words, while it's good to look, African states were very concerned about the day-to-day mechanics of how the ICC was run, a proper review of the ICC cannot be separated from its geopolitical significance and all of the issues attendant on that. Because while we were looking at, for example, the proposal to amend Article 16 and the role of the UN Security Council, that debate about the UN Security Council's role in relation to in the broader scheme of things was also being considered in the African Union context. So this is the sort of context within which I framed the research that I did. And I looked at three specific issues, which in my view appeared to be the core issues that were of concern to African states. The first was the peace versus justice debate. The second was complementarity, and the third is the issue of cooperation. So in terms of the peace and justice debates, and obviously I preface all of this with a more general look at African states' contribution and support historically for the ICC. So that the paper is framed in that way. And I move beyond that initial support to looking at, for example, how that shifted. I call it a shift in the wind once the arrest warrants began to be issued for the African heads of state, not when Thomas Lubanga was indicted, but once the first arrest warrant was issued for President al-Bashir. And then when the Kenyan indictments came out. So that shift is what I argue led to issues around cooperation or not, the calls for non-cooperation by the ICC. I referenced quite a bit Professor Jallo, who has written extensively on this issue, particularly in relation to taking a nuanced look at who are we talking about when we say African states. My colleague Roland, I think, mentioned that. Because again, it was not a homogeneous response. So there was the African states response, so individual states who are states parties, and that even there were divergent approaches. So Botswana stood out as one of the sort of divergent, the voice away from the mainstream. Then the AU response, do we separate that from the African state response? So there were different responses. And then African civil society response, which didn't always fit with the state or the AU response. And so looking at what we saw happening with that shift, I think the broader question that I had to assess was how exactly did the IER address some of these concerns? And I found myself up against what I think Ambassador Kanu alluded to, and that is structurally how the IER was set up. So you had a formal mechanism that was set up to deal with specific technical, mechanical issues. So, we know them. I don't need to go into detail. But then the matrix which set up the IER said the other broader, what I call the geopolitical issues, were now to be left for the assembly mechanisms and facilitations to deal with. So you have the facilitation on cooperation, which is, I think, co-headed by Uganda. You had a co-facilitation on complementarity. So the idea was those ASP mechanisms would deal with those issues. So it then led to the interesting question, because can we really separate this, or is this separation a bit artificial? And the question was difficult. I cannot tell you that I answered it. I read back my paper and I'm not sure I did, because the IER did touch on some of the issues. I'll start with complementarity. In dealing with the complementarity issue, for example, they looked in detail at the prosecutor's approach to preliminary examination. They looked at the issue of, the prosecutor's selection, issues concerning bias, prosecutorial bias. These are fundamental issues. African states have been saying this from the beginning. We understand that. But there were other issues which were not touched. For example, the question of regional complementarity, which is an issue that has arisen because of the Malabo Protocol, as to whether or not the only individual state should be able to refer cases to the ICC, or whether the complementarity principle envisages regional mechanisms like regional courts. Then the issue of positive complementarity was not looked at in great detail either, because the positive complementarity issue, for those who have been following the ICC for some time, is rather sensitive, because the question is the ICC expected to be a court that that builds capacity of local courts? Now, those of us who are in the room may have heard that the prosecutor has now put out his new complementarity paper, which I am still yet to study in great detail. Very interesting. I personally did not see that the IER mechanism has fully engaged with this issue as to what positive complementarity is to look like. So there are still some questions to me as to whether the IER engaged with this issue, which were core issues for African states. That's the first issue. On cooperation, and I'll move very quickly because I'm watching Professor Jallo. Again, the issue of what does cooperation look like? This call for non-cooperation by the AU. It engaged other core issues of relevance to African states, including the role of the UN Security Council and what that looks like in that frame. And I would say last but not least, the issue of peace versus justice, the question of sequencing, feasibility, and that sort of thing. So I throw these out only to say that in my conclusion, I felt as if that there were some of the proposals that remained proposals. They were there. Kenya made a formal proposal to the working group on amendments in relation to this issue of regional complementarity. But when the Kenyan cases began to collapse, I checked. I did not see any movement again on some of these issues. But I did think it was an amazing opportunity for engagement, but I don't think the opportunity has ended based on what I'm hearing the ambassador say. And the only thing I didn't get to do is to examine the civil society perspective on this, so I had to exclude that. But I invite you to look at some of what my other colleagues have said and this paper, because I think that the African voices in the room, in light of what is happening now in the geopolitical space with the ICC, it's very important that the voice is not be forgotten. Thank you very much for your attention.
Thank you very much, Lorraine, and thanks, of course, to all the panelists for really rich presentations on their papers. I will underline that what you've heard from them is really small vignettes of the heavy work that they did over the course of about a year in terms of research. I would not attempt to summarize the papers. I do have summaries of the papers here, but you've been listening very patiently for about 30 minutes or so now. Slightly over, and we have a little bit of a problem in the sense that we have lunch sitting outside, but we also have a particular time when we're supposed to vacate the room for the next event. And this is something that is way beyond my pay grade because it concerns the UN rules. So I'm not going to attempt to fight the United Nations. What I will do is basically open the floor because you've been very generous with your time in participating in the event, to invite you to take advantage of the opportunity we have, which is essentially 3 African experts who have looked into issues of particular concern, which in very many ways reflect the vision of CILPA. And Lorraine, yes, Africa and the diaspora is part of Africa. So there's no need to explain yourself at all in terms of your engagement with this issue. So I understand, of course, the impetus, but we think of Africa in a very rich way at CILPA, and that, of course, will always include you and many others in the diaspora, all the way to Brazil and the United States and well beyond. In fact, the whole Mother Earth, right? It's a friend, it's a cradle of the world as a whole. So let me open the floor to questions for our experts. And if you have general questions, feel free to frame them into specific questions to particular panelists. And I already know we have a lot of experts in the room. I see Chief Taku, who is no stranger to many of us. Chief Taku, you get to ask the first question.
From the background, 25 years of participating in the trials in all the courts. Lately, myself and my friends and clients recently moved up with the problem of politicization of electoral justice at ICC-Africa. That explains why the Congo is on fire. But the government with the ICC have been involved in this debate for a long time. I looked about that. One of the problems with Africa is we're able to argue that the people who commit crimes in Africa are not necessarily Africans. The world has changed on the way down. That somebody can be in New York and be the person committing the crime, so very weapons. So the investigation was the wider. We didn't say that people should not come to Africa. But with Africa is one of the The international multilateral treaty regime that Africa belongs to is very, very wide, including the Geneva Conventions. On the continent, Africa has more treaties than any other continent in the world, but none of them is operational. The international system is broken. The United Nations, completely broken. They don't care about Africa. The ICC has been focused or supported. Indeed, the number of complaints coming to the ICC and the evidence sent to the ICC in respect of crimes committed in Africa makes Africa the highest. They have a body of information sent by the civil society and victims. I'm coming from the southern Cameroon, where more than 36,000 have been slaughtered. More than 1.7 million have been forced, deported to Nigeria, and 675 settlement villages burned down. And there are several complaints that neither Nigeria nor any other country nor even Cameroon at the ICC have made a statement. With complementarity, the ICC must look wider, not only about the question of state, but we need what we call institutional dialogue. That even if they cannot intervene in a situation, they should be able to submit evidence to authorities, either united jurisdiction or other jurisdictions that might take up the case and give them the evidence, so that at least no victim, no crime is there to touch. Secondly, the civil society in Africa is not organized. We see them, we know they are alive here, or when they're making statements in the press or during political campaigns. We need an international conference of African NGOs, civil society, to constitute themselves into a very powerful force to force Africans in order to ratify the Malabo Protocol. Because Malabo Protocol criminalizes more offenses than any other treaty, including ICC. Now there are 15 countries that have so far signed. We need 28 to be operational. The civil society can do that. Forget the hostility. Nobody undermines them because it is chronic. And the people in government making the determination are our friends. The African civil society need to call an international conference of African civil societies in Africa will come out with a structure where we play the role that we're supposed to play, not only to be seen in conferences like this. After the conference or press conferences, that is the end of it.
Thank you very much, Chief Taku. Let me do this because I know that we're short on time and we don't want to leave you a few minutes to have a bite of a sandwich, if you'd like, at the Vienna Cafe on us. I'll take a series of questions, and then I'll go over to the panelists. So if you keep it short, I recognize you, ma'am. You have the floor.
My name is Beth Lyons. I'm here representing the International Association of Democratic Lawyers, and I'm a co-counsel with Chief Foster on the Onward case. And my question is about positive complementarity. Based on what I've seen over the last decades at both ICTR, but especially ICC, the conceptually complementarity is applied to prosecution and investigation, but particularly prosecution. You know, the state's help in prosecuting, finding fugitives, etc., getting the defendant into the dock. My question is this: whether positive complementarity, which the last speaker just mentioned, considers the issue of complementarity conceptually and its importance in relation to the issue of sentence. The reason I'm talking about this is it kind of intersects with the cultural issue. In Onward, the defense asked for, if Onward were punished, he'd be sent back to his communities to be dealt with by the elders and go through Matu or Put and go through the traditional justice systems. Just simply, I'm not speaking on the Onward case, but the court ignored it. That's just a fair summary. They said, no, we're not going to do it. We're not interested in evidence. So that's why conceptually, I think complementarity, I'm making the issue of complementarity as applied to sentence as a conceptual issue that should fall within or doesn't fall within the framework of positive complementarity. That's my question.
Thank you very much. I'll do a last two questions. I saw there was a hand on this side of the room. And then I'll take my compatriot over here. So, ma'am, you have the floor.
I just wanted to whether you've had any reflections on the structure. You commented on the structure of the IER, but has there been any reflections on the way that it's been taken forward through the review mechanism and the future of the review mechanism is under question? And I just wondered if you've had any opinions on how that should be best be taken forward. Thanks.
Thank you very much, and also for being brief. I think we'll take the last question from Ibrahim.
Ibrahim Miller, I'm the vice chair of the Trust Fund for Unity. I'm happy you're here. You were there yesterday when I presented my paper. So one of the things I'm actually looking at, in the paper that we presented for the close of reparations in the Katanga case, it's actually the Rome Statute. When you look at the preamble, it's actually about victims. The entire system, the Rome Statute system, it's not a victim-centered approach. I have worked in the office of the prosecutor for more than a decade in the defense, and now in the Trust Fund for Victims, and I know the importance. Initially, I thought the most important organ was the prosecutor's office. But as I work now with the Trust Fund for Victims, I realized that there was a method, to be drafted, insisted on a victim-centered approach in the home statute system. So one of the things I would like to put forward, and we made an argument in the last Nuremberg conference, much as we're all interested in building jurisprudence, but I would like, there's a bit of a shift from the victims who the home statute system should be all about. So when we talk about complementarity, can we also encourage states which have primary jurisdiction over the crimes listed in Article 5 to also implement in their legal system legal mechanisms for giving reparative justice to victims? I think positive complementarity should also be viewed from that sense. That's just a comment I will make.
Thank you very much, Ibrahim. So we have 4 questions for our panelists. So let me go directly now to the panelists to answer the questions that they would want to address. You don't have to address everything. I think a number of themes have been raised. They really center on a couple of points. One, the question of complementarity, framed in a positive way. What does positive complementarity mean? I think the initial questions related that to the issue of sentencing. And you would notice that Jeffrey Logano in his paper spoke about the death penalty in African states. So the element of sentencing comes in that way, but also now a positive complementarity in relation to the question of victims and victim-centeredness of the Rome Statute system, and to what extent does the complementarity regime accommodate or push or require African states or states more broadly to put in place mechanisms to address the concerns of victims. And there are, of course, the big picture questions concerning the structure of the review process from our colleague in the back. So maybe, Lorraine, I'll start with you on any of these issues that you'd like to address.
Thank you very much, and thank you for some of the questions and comments. I'm going to touch on the complementarity issue. As I said, Beth, thank you for your question. We've seen that the prosecutor has the new complementarity paper, and I think he has framed it based on, obviously, the office's position around the complementarity issue. But at the level of states, for example, in the context of the facilitation, I have to say I could be corrected. I have not seen where the issue of positive complementarity framed contextually, as you said, to include complementarity from the perspective of sentencing has been an issue that states have taken up. And without states taking that up, I think the judges are going to stick pretty much to the letter of the law in that regard. In terms of positive complementarity, though, the OTP's approach is that, what is it? The ICC is to be a justice hub, I think they call it. So basically not the apex of prosecution, but it's to be shared. So the broader question, I think, with complementarity, and to link it to your question around victims and where they fit into the broader complementarity regime, if we go back to the core principles in Article 17, it says that the primary responsibility is for states. They have the duty to look at, to investigate and to prosecute. Positive complementarity is a nice framing of this whole discussion in terms of, but it raises other issues which you don't have time to get into. I can speak to you about it, but it raises questions as to whether the ICC should be the one setting the standards concerning even sentencing and all of this. I mean, it raises a lot of issues, but we can talk more about it outside. So I can't answer that, but I agree with you. And there's a term with victims that they are using called reparative complementarity, which is there a burden sharing then that is supposed to happen between states in relation to complementarity and victims and reparations and the ICC? So that is also being put under the rubric of complementarity. So complementarity is a big issue. One quick question on the future of the review mechanism. I think you may have missed what Ambassador Kanu said when he was here, but again, the idea is he's saying, I know that the future of the review mechanism, it seems to be a little bit under threat, but I think what he's saying is that I'm hoping at this assembly they will see the value still of continuing that, and that the African states will see the value of engaging further in the process. Charles, I'm going to leave it there, knowing that I haven't touched, because there's just not.
We just don't have enough time. Thank you very much, Lorraine. And I'm actually going to be very rude now and give about 30 seconds to my last two speakers. And unfortunately, I have to do that because we have to get out of the room. And I'm hoping that the invitation to at least a few minutes at the Vienna Cafe with some sandwiches, we can continue the conversation. So maybe I'll go to Jeffrey, 30 seconds, Jeffrey, and then, of course, to Roland as well, 30 seconds. I apologize, of course.
It's okay, sir. So I think I'll just speak to the idea of complementarity and positive complementarity. I think, these are conceptually different things. The one concerns a cornerstone of the Rome Statute, of course, it's mentioned there. But positive complementarity was kind of some additions, like innovation within the Rome Statute advocates, because it's not mentioned anywhere in the Rome Statute. And it was thought of as a way of encouraging states to build a capacity so that they could also come at speed with prosecuting international crimes. So conceptually, there are different concepts, but of course, the goal is to contribute to prosecuting international crimes. With regards to the death penalty, I think I didn't really clearly get the question, but I think the trend is to abolish the death penalty, and countries that are still prosecuting international crimes and having the death penalty, are being encouraged rightly to abolish them and have more, I think, less severe sentencing procedures. Because, of course, the Rome Statute doesn't really give clear guidance on how to proceed with this, but there is this trend of not really going in the direction of having the death penalty, even for the more serious international crimes.
Thank you very much, Jeffrey. And Roland, you get the last word. Also 30 seconds.
Thank you. No, from my side, what I would say is we Africans and our African leaders need to work on the substance to be able to put forward our idea, to formulate them in legal norm structure and engage with other states as it's done in international law to get these norms on the table, discuss and outcome so that there is no complaint in the corridor that we have not been heard. We can be heard, we have the expertise, and let's make it work. Thank you very much for the opportunity.
Thank you very much, Roland, and thanks to all the speakers and all of you for your incredible patience. I think you all deserve a big round of applause on the sandwich, so I'm going to ask for the round of applause. And let's go have a sandwich. Thank you very much. Obviously, the conversation has to continue, so we invite you to further engagements with all our experts, and we'll be in touch with all of you. Thank you very much for the opportunity to engage with you. See you at lunch at the Vienna Cafe, just right outside the door to the second left. Thank you.
Oh, it's gonna be checked.
Yeah, they will see. Okay.
Thank you. Oh my gosh. Really?